Hey, it's Josh Boorman here from Boorman Lawyers. I'm just outside Blacktown Local Court. Appeared on a middle range drink driving offence today where the blood alcohol reading was 0.089. So it's just crept into the middle range category there, given the middle range category in New South Wales is between 0.080 through to 0.15. So it's at the bottom end. This matter before the court today was a relatively stock standard type of drink driving offence. There was nothing aggravated about the matter. My client, it was the day of his birthday. He'd finished work. Some friends had invited him over to their place for a surprise. And the surprise was that some of his friends from Melbourne had unexpectedly come up and wanted to celebrate with his birthday. He obliged and he went over and he ended up consuming 2 to 3 glasses of full strength beer between about 7 p.m. at night through to 9:30 p.m. He had some prior obligations of getting home that night because he had pre-arranged a video call with his family back home in India because they'd organised a birthday cake to be sent to his place, and he was going to go back, jump on the video call, cut the cake and celebrate with his family over the video call. So he did make that foolish decision of getting into the car to drive home. He self-assessed his sobriety. He was of the view that he felt fine, unaffected by the 2 to 3 glasses of beer that he consumed earlier. So he jumped into the car and drove home. Now, he was pulled over for the purpose of a random breath test, or a stationary random breath test setup site. So it wasn't his manner of driving. He wasn't speeding, driving erratically. There was certainly no collision, nothing sinister or of that nature. He was pulled over. It was a positive reading, and a final BAC reading of 0.089 was recorded. So he was charged with middle range drink drive. It was the first offence for him. He has no prior criminal record. He has a very good traffic record with only one more minor speeding offence on his record, which attracted a 1 demerit point, and that was about 12 months ago. So a very good record, absolutely nothing aggravated about the matter. The reading was towards the lower end of the middle range category. And he did all the right things since the offence occurred. He did the traffic offenders program. He disclosed the matter to, he works 2 jobs. One job is as a civil engineer draftsman for a company, and he works Monday to Friday 9 to 5 in that job. He disclosed the matter to his employer and got a good strong letter of support from his employer. He has found himself over the last couple of years in a bit of financial difficulty. He ended up borrowing about $18,000 worth of loans to support his family back home in India and help them fix up their home. So he has been taking on a second job as an Uber driver at night time and on weekends. And we were able to obviously show the court receipts from those Uber payments over the last few months, and obviously it stopped when this offence occurred, because when the offence occurred his licence was suspended at the time. So that has significantly reduced his income and his ability to pay back those loans. It has left him in quite a dire financial situation. So getting back on the road was incredibly important to him. Today, we pushed for a non-conviction order under Section 9(1)(b), but that came with a Good Behaviour Bond. He's got to be good behaviour for 18 months, cannot break the law during that period of time. It means he's not convicted, he can resume his driving abilities, he's not subject to an alcohol interlock order, and there was no fine forthcoming. So a very, very good outcome today, very positive. It was certainly what my client was hoping for. As I have told him all along, there's certainly no guarantees in getting a non-conviction order. Ultimately, the decision is in the hands of the court, but what is in our control is the steps he can take since the incident occurred, the preparation, the letters to support, the traffic program, any other material that we are able to rely upon to push forward a persuasive case for the court to give our client maximum level of leniency. So certainly the facts and his good traffic record were big points that actually worked in his favour in relation to this matter. But all the supplementary subjective material that we presented were also persuasive in allowing the court to use its discretion not to record a conviction on this occasion. So he's a very, very relieved client. He's a very good man. He's a person of good character, supports his family, works hard, and I don't think we'll ever see him back before the court making such a foolish mistake ever again in the future. So thanks for tuning in to Boorman Lawyers here at Blacktown Local Court in Western Sydney. I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel because we've always got fresh new content coming through all the time.